This is Charles Green. I am an attorney here in Los Angeles, California, and I specialize in family law. I practice mostly in the Los Angeles Superior Court. The majority of our cases are in the Hill Street Court, which is about 5 miles from my office here in the Mid-Wilshire area. I'm going to talk today about the attorney's fees. The attorney's fees for a divorce. That is one of the most common questions I get from the public. People ask, or prospective clients, people ask, how much is my divorce going to cost? Well, simply stated, how much it's going to cost depends on the extent of disagreement between you and your wife, or you and your husband, you and your spouse, you and your partner. That's how much a divorce will cost. If you guys want to fight about every single detail, it's going to cost more. If you're both willing to compromise on different things, it'll cost less. Asset division can be very expensive. Custody litigation can be even more expensive than asset division. Okay, but let's talk about the funds. Where do the funds come from initially for a divorce? So it's very common. Somebody comes into my office. The first question, I want my spouse to pay for the divorce. Well, in my office, the client that signs our legal services agreement is going to have to put down a deposit. Okay? So you have, even if you're what we call the out spouse, the spouse that doesn't have much of the resources of the community, you still have to come up with something. So plan ahead or talk to your friends or family. You're going to need some money to get this started. There's going to be filing fees. Occasionally there can be a filing fee waiver. But there's going to be filing fees, there's going to be process server fees. You're going to need some money to get things started. There's going to be fees to get an initial RFO, that's a request for order hearing for support, okay, and attorney's fees. So now let's talk about that request for order hearing. Okay, request for order hearing is a type of summary proceeding, a quick hearing in which the court makes temporary orders for the duration of the divorce until there's a judgment usually. And these temporary orders can cover attorney's fees, expert fees, filing fees, different types of costs related to the divorce. Can cover an appraiser. Okay, but generally, it would fall under Family Code 2030. Family Code 2030 requires the judge, on a proper showing of need, to help the out spouse, to make the playing field kind of equal. The law, simply stated, is not discretionary to the court. Now, there's always a little discretion, but the court must help an out spouse with fees. Must even the playing field to a certain degree. All right. Does everything always work perfectly? No. But there is an aspiration to try and even the playing field so that even the out spouse, the spouse that wasn't managing the checkbook, the spouse that doesn't know much about the family finances, can have money ordered from the other spouse or ordered from an account that may be not accessible to one or the other spouse, to be used for fees and costs and possibly experts. That's Family Code 2030. There's other types of attorney fee statutes that have to do with, simply stated, a penalty for frustrating the progress of a divorce. Okay, but those are more of an exception to the regular award of attorney's fees 2030. Okay. But let's talk about what a divorce will cost. Well, if you want precise information, okay, precise information is expensive. Okay, if you're willing to let your attorney use his or her expertise to guide you on what would be a fair division of assets, then you can keep the costs down. There are times when you're going to trial and an attorney's analysis is not adequate because your attorney can't be an expert. So, for example, if you need what's called a Moore-Marsden analysis, which is an analysis of the community interest in a separate property residence. In other words, if you lived in a house that your spouse purchased before the marriage, okay, and now that you are both paying the mortgage on that with money you're earning during the marriage, that creates a Moore-Marsden interest, okay? In those instances, you're going to need a forensic accountant to present an analysis of a Moore-Marsden calculation, which is another way of saying the community interest in the house. Okay, so you need fees for that. Okay, what else can reduce the fees? Well, don't hide things from your attorney. Be honest with him or her what's going on, and try to compromise. Try to compromise. All right, because the more money you spend on attorney's fees, the less there's going to be for you and your spouse from the community. So fighting about who gets the couch or this antique table over there, or quite often people fight about the family album, that's going to waste a lot of money. But that is your decision. Okay. But what I'm saying about attorneys is you should hire an attorney that is comfortable and has the expertise, the financial expertise, and the communication skills to tell you what is a fair division of the assets, okay, that is good for your family situation, not just a divide everything down the middle. How can we divide these assets to cause the least disruption to the two of you, the children, if any, okay, to the community, the least disruption and the least expense? Okay. If you want perfect information, you could spend a small fortune on forensic accountants analyzing everything, including the lifestyle that you enjoyed during your marriage. Okay, they can spend a lot of money on that. Okay, and again, that is sometimes money that is taken from the community, unless one spouse is an extremely high earner. Settlement. Settlement is the way to reduce your attorney's fees. Attorney's fees are usually hourly. The only time that my office would ever do a case that is not hourly, or most attorneys, is if it is a very, very simple default divorce. Very simple. Then maybe you could have a flat fee. Maybe. But most attorneys in family law would not take a client on a flat fee for a contested case, because there is no motivation for the client, for the litigant, to settle then if they have a gripe with their spouse. So it is very important for the parties to know that they are going to pay more money if they don't compromise. Okay? Sometimes you can't compromise. Sometimes your spouse is just not going to come along. Sometimes the positions of both people can be reasonable and the court has to decide. So each case is different, but everything you do in the case, you should think about the fees. Most attorneys charge for every phone call and every email. What you are buying from an attorney is time. You are buying the attorney's time. That's what the attorney is selling. Their expertise through time. Their expertise in preparing papers, in preparing documents, their expertise in negotiating. Okay. So you want to find an attorney that has good communication skills, that will be financially sensitive to you and your spouse's situation, and not waste the community away on unnecessary litigation. And you want an attorney with financial expertise. If you have a material community, if you have a financially sophisticated community, you don't want to go hire an attorney that's emphasizing custody litigation. Okay? You want to hire an attorney with financial experience. And there are some out there. So if you have things like stock options, separate property interests, a business, several businesses, investments, retirement plans that are going to need to be divided, retirement plans that have interests from before the marriage, okay, investment accounts that have interest before the marriage, interest after the marriage. You need an attorney that is financially sophisticated. Okay. That attorney, even with financial sophistication, might still need to employ experts because your attorney cannot be a testifying expert in court. Okay. But if you hire an attorney that has financial experience, they can understand the situation better and interact with any experts in a more leadership, intelligent role, as opposed to relying on the experts to educate the attorney on the different financial vehicles. Okay, many times an attorney can help the expert if the attorney is financially competent. When it comes to custody cases, we are very experienced with custody and visitation litigation, and we'll do what we can to help you. But endless custody litigation, evaluations, bringing in experts, very, very expensive in the custody litigation arena, so to speak, in the custody litigation courtroom. So my advice is always focus on settlement. As soon as to mitigate attorney's fees, always use every opportunity to settle part or all of the case. All right. Sometimes you can just settle a small part of the case, and it may make sense. Other times you don't want to do that, but always be focused on settlement. Constantly try to steer the case to settlement, to resolution, to end the attorney's fees. You should, no matter what part of the divorce process you're in, you should be focused on reducing the attorney's fees if possible through compromise, through information. Okay, information makes people more comfortable in settlement. So even if you're an out spouse or an in spouse, the spouse with the information, the quicker you hand that over to your partner's attorney, the quicker the information can be processed and you can reach resolution. Every case is different. Every case has a different amount of fees. Okay. One of the most common problems I find from people who this might be their first time dealing with the legal system, dealing with an attorney that they've hourly on an hourly basis, is in the beginning of the case, they get a little too chatty. Too many emails, too many questions, too many what's going on. Most attorneys charge for everything that utilizes their time for your case. So if you're going to communicate to your attorney, do it wisely, okay? Save up your questions and send one email, okay? Think about whether your questions are really necessary at this time, or can you wait until you have interaction with the attorney for some other reason, okay? If you send constant emails, you're going to be charged for that, okay? So you're using the attorney's time. So the way for the public to understand how they're charged is anytime you utilize your attorney's time, it is likely going to result in a use of your deposit, in reducing your deposit. So now let's talk about the deposits. Usually you'll make a deposit to the attorney. Many times the attorney will, when that deposit is going down, okay, that many times attorneys will send you a statement, and that statement will show how much of the deposit was used and what it was used on. So the attorney's statement should be detailed. It should say this phone call, this email, we wrote this paper, we analyzed this tax return for you, we wrote up this custody agreement, this proposal. So this should all be outlined very clearly on a detailed statement explaining how your deposit was used up, and then showing how much of your deposit you have to replace. Okay? Most attorneys require an ongoing deposit if your case is in controversy, if there's ongoing litigation. Sometimes attorneys ask for a trial deposit because a trial is going to take a big block of time. An attorney will estimate what the time is, and they will request you to deposit the amount for the trial to demonstrate that you have the ability to pay for the trial. Okay? And then other times, if you have a comfortable relationship with your attorney, you both got to know each other, you pay the bills when they come there, your attorney may at some point allow you to pay as you go and not have an ongoing deposit. But that is usually the exception. The general rule is you have to have a deposit with your attorney. That deposit gets used up based on the hourly rates, and you get a detailed statement. Now let's talk about hourly rates for a moment. Each attorney usually has a different hourly rate based on their expertise and experience. So the attorney with more experience will likely have a much higher hourly rate than an attorney with 3 to 5 years experience that's working in the office. So there should be varying rates on your statement for which attorney worked on which part of your case. Okay. And this should all be outlined in your legal services agreement. So the answer to the question, how much my divorce will cost, that's a question that can't really be answered, okay? But the correct way to deal with the fees and the costs is to manage them in the most efficient and useful way possible for each situation. And your attorney can't do that alone. You have to help. And you can't do that alone either. Your spouse has to be on board with managing the overall costs of the divorce. So it's up to the attorneys and the parties to look for places where they can compromise and try to find compromise to minimize the fees. Now, sometimes there can be domestic violence litigation, which is one of the most common types of litigation that is filed in the Los Angeles family court. If one party wins the domestic violence litigation, all right, the court can award fees the court can award fees to a prevailing party, okay, for the domestic violence litigation. So be cautious before you file a domestic violence case, because if your domestic violence case is not solid, you could end up paying your partner's fees for defending that case. And also pay close attention to the timelines necessary to file a request for fees for a prevailing party in domestic violence litigation. All right, there are timelines for that. If you have a relevant family law case that you'd like to discuss with me, give us a call here at the office, 213-387-4508. We're located here in the Mid-Wilshire area, and I hope if you're interested in discussing representation, that you will contact us and see if it's a good match for both of us. Thank you very much, and good luck to you.